Yes, Mr. Moretti.
May it please the court, I appear on behalf of the CICA in this appeal,
Yes.
and also the Secretary of State for Justice, who is the interested party in respect of the human rights argument. My learned friend, Mr. Butler, represents LXR with Mr. Boswell. The other party in this appeal, obviously, is the First-tier Tribunal, which, as usual, was not present or represented below, because it's a court whose decision is challenged. My lord, there are a few housekeeping matters, if I could deal with quickly first. The first is, obviously, as the court will be aware, the applicant below and the respondent to this appeal is known in this appeal by the pseudonym LXR.
Yes.
That is on the basis of the Sexual Offences Amendment Act 1992 applies. So there are redactions in the bundle in order to ensure that, and it's important, obviously, anyone watching this is aware that that anonymity order continues.
Correct.
Secondly, in terms of papers, you should have before you a call bundle and a supplementary bundle, and then a bundle of authorities. And in addition to that, Mr. Butler provided on Monday copies of the DSM-5, parts of the DSM-5, which he asked to be added to tab 66.
Right.
He's got hard
and
copies.
you can take it that we have read the decisions of both tiers of the tribunal, and we have read the skeleton arguments, including supplementaries cases.
And then just in terms of timetabling, there is obviously, I've spoken to Mr. Butler, and our plan is that I will open on my appeal, and that will hopefully take us to sometime soon after lunch, about 2:30. Mr. Butler will then respond to that, and he will also open on his cross appeal, which is essentially the human rights argument. That will hopefully take us around 11:15 tomorrow, and then I will reply on that and reply to his reply, and he will finally reply. It's somewhat complicated, but that is technically, I think, how it should go.
Yeah.
Thank you. So the central issue in this appeal is relates to the correct interpretation of paragraph 115 of the Criminal Injures Compensation Scheme and its application to the factors found by the First-tier Tribunal. Now, putting our position at its simplest, and our belief is that these proceedings have become overly complex, and they are in fact very simple. But our position at its simplest is that the First-tier Tribunal carried out a detailed analysis of the medical evidence before it, including exactly 1,000 pages of medical documentation, and found that there was no material change in LXR's medical condition as defined by his symptoms and diagnosis. Now, in short, we say in circumstances in which the First-tier Tribunal found that there was no material change in his symptoms and diagnosis, it cannot plausibly be said in terms of the scheme that there has been a material change in his medical condition that would permit an award to be reopened. And essentially, the question of diagnosis, the tribunal found that there was no change in diagnosis, but it didn't need to go there. Essentially, the real issue is symptoms. What are the effects of one's medical condition, or as the Upper Tribunal put it at one point, disablement? That is essentially what one is looking for. And if one considers one's symptoms or disablement, that is how your injury affects you, what you can and can't do, how your bodily functions are affected, where your pain, what your pain is. Where they're the same, where that disablement is the same and hasn't changed, it can't plausibly be said, we say, that there is a material change in your condition, medical condition, and certainly not so material a change that injustice would be caused if the matter wasn't reopened. And so that's a simple point of our appeal. And we say that the Upper Tribunal was wrong to overturn the First-tier Tribunal's decision on the facts, and that's what it was. And that in those circumstances, it can be reopened. And no matter, unfortunately, whatever the sympathy one may have for Mr. LXR, one can't distort the wording of the scheme to allow his particular case to be reopened, because obviously my client, the CICA, has to apply the scheme, and the First-tier Tribunal has to apply the scheme. on a
Can I
day-in,
ask
day-out
you a
basis.
procedural question, which actually is not of direct relevance? But why is a challenge to the FTT brought by way of judicial review rather than a plain vanilla appeal on a point of law from the first tier to the upper tribunal? What's the policy reason behind it?
I don't know what the policy reason behind it is. The reason is that I think it's within the
Well, if
you
you don't know, you don't know.
particular
But
provisions there.
it just seems to me that it would be more convenient in many cases if the upper tribunal were able to remake the decision rather than send it back to the FTT. And we are.
Yeah, so there's a clear difference in terms of the upper tribunal's jurisdiction in a criminal injuries compensation case where there's a judicial review, and so they don't have the power to remake the decision.
Is this not covered by the 2007 Act?
I think it's an amendment.
That provides a route
Yeah.
by way of appeal on a point of law, isn't it?
This is an excluded
This is an
decision.
excluded,
Is
it's an
that-
excluded
is that the
decision.
answer then?
Yeah.
There are provisions somewhere which set out what are excluded.
Yes,
decisions.
this is an excluded decision, but the question is, well, why?
My lord, I don't know. I can look into it and see if I can provide any further detail on that tomorrow. But I'm not sure there is a policy answer, and I certainly think it's probably something that I have looked at before. But that is where we are. In terms of the reality is that there is not an enormous amount of difference between the jurisdiction of the upper tribunal on dealing with the judicial review and the jurisdiction of a court in dealing with an appeal. So there was
Just my
there's an
idle
error
curiosity. So
on a point of law.
Yeah, in substance, as I understand it, this was a claim for judicial review, and therefore the only basis on which the upper tribunal could interfere with the FTT's decision was if there was no error of law.
Yes. And that would include if the decision was perverse, for example.
Yeah, we don't need to go in there. Obviously, judicial review lies on many grounds, but here the essential question was: has the FTT committed an error of law? You say they hadn't.
They hadn't. Now there is a separate sort of procedural point, which we say it was wrong for the upper tribunal to, in essence, overturn the decision of the first-tier tribunal in circumstances in which LXR himself and his representative had quite properly come before the upper tribunal and said we cannot and do not challenge the findings of fact that there has been no material change in the medical condition, symptomology or diagnosis. What happened in the upper tribunal below is that the LXR was bound to, because he was represented by experienced practitioners in judicial review, knew he couldn't challenge the findings of fact and therefore sought to make a different argument to say that what the FTT did went wrong and considered not whether there was actual change in the objective medical condition, but should have ascertained whether there was a change in the reasonably ascertainable medical condition. And that was the argument that was being run, and that was the argument that LXR properly said before the upper tribunal. That's the argument we're running. We're not trying to challenge the questions of fact. And moreover, what the upper tribunal then did was provide guidance which we say is wrong in principle and simply impossible to apply. And certainly what the CICA needs and what first-tier tribunals need is clear guidance as to what a change in medical condition actually is and how you approach that. And we say the upper tribunal was wrong to say that where there is no change in symptoms, there can be a change in the medical condition to allow a reopening. And certainly think matters such as an understanding of a condition or the cause of a condition cannot be a change in the medical condition. And I say the reality is, we say where the symptoms are materially the same, how it affects you It can't be said how it disables you. It can't be said that there's a material change in the condition.
The Upper Tribunal said this at paragraph 33, in the final 4 lines. If I have understood Dr. Law's evidence correctly, it is that LXR's understanding of his symptoms, I think that must be symptoms rather than systems, the type, and their causes was fundamental to the nature and treatment of his condition. I see no reason why that should not be a change in his condition, provided the tribunal accepts that evidence. On the face of it, that appears to be a proposition of law. So it may be right or it may be wrong, but on the face of it, it appears that the Upper Tribunal was saying that the FTT had erred in law for this reason.
Well, that is wrong for a number of reasons, we say. I mean, firstly, because that was not the case that was actually advanced in the First-tier Tribunal. And just to address that, if one looks at Core Bundle 303, at paragraph 34 to, begins at paragraph 32 at Core Bundle 302. This is the claimant skeleton argument for the First-tier Tribunal. There has been a change in 3 main ways. That's paragraph 32. 1 is diagnosis. 2 is the appellant clinically significant understanding, and 3 is a symptomatic deterioration. And I will come on to diagnosis in due course, but the relevant part about the understanding is at paragraph 35, which is relying on the evidence of Dr. Carolyn Law, explains that the appellant is now able to understand and accept that the root of his injuries was the historic abuse. Then says this in itself is a significant change in the appellant's condition because of its symptomatic consequences. And that is what the argument was below, which is how one understands a condition cannot of itself be a material change in the condition itself. And we say obviously it can't, because you have a medical condition, what you understand about it can't change the medical condition itself.
Well, that seems to be what Dr. Law was saying. If you look at report or letter or whatever it was, in the supplementary bundle at page 205, she talks about LXR's ability to understand that the root of his injuries is the childhood sexual abuse, and then she goes on to say these changes have led to a significant deterioration in his condition, and that the FTT rejected on the facts.
Yes, absolutely. So,
and I think in her subsequent document, which is post-dates the FTT, she's asked, why do you consider the change in understanding of the cause as a change in his medical condition? And her answer is a change in understanding is a change in his medical condition due to the fact that this change in understanding led to a change in symptomatology and presentation, also rejected on the facts.
Absolutely. And so that's at S116. And so that, let's say the case has put below by Mr. LXR's representative was clear it's because of the change in symptoms that a change of understanding could be a change in medical condition. Dr. Law's evidence is clear, certainly in the subsequent report, that is the reason she is saying it can be a change in medical condition. And that was the argument that the First-tier Tribunal were addressing, and they rejected that. And they rejected it going through in detail the medical evidence that was before them. What I will do shortly is just go through how the case developed, because it is important to see how the case developed. and why the first-tier tribunal was entitled to reject that on the facts. Can I begin first by looking at the scheme? I think that's an important place to start. So that's at tab 3 of the authorities bundle, page 70 of the authorities bundle, which is the second part. So obviously, the core of this deals with paragraphs 114 to 116. 114 provides the claim officer with the discretion to reopen if certain conditions are met, and those conditions are set out in paragraph 115. Obviously, if they're not met, there is no discretion to reopen. Paragraph 115 sets out what those two conditions are: that the person who has accepted award has died subsequently, and that there has been so material change in the medical condition of the applicant that allowing the original determination stand would give rise to an injustice to the applicant. Now, we say, and it's important, that when one reads that and the interpretation that the court gives it is one that is easily understandable and can be easily applied both by the CICA and by first-tier tribunals, but also by people applying for compensation or considering whether their matter could be reopened. And we say, one of the difficulties with the Upper Tribunal's decision is they say that the wording is inherently vague, and that's the utility of it. And we say, well, that's not the correct way to approach legislation. The correct way to approach legislation must be to ensure that it can be simple, easy to understand, and easy to apply. And that's one of the reasons behind the scheme in the first place when we come to the human rights arguments. And I say, simply standing back, if you have a situation where there has not been, as a matter of fact, a material change in symptoms or material change in diagnosis, then simply as a matter of fact to the ordinary person, it's very difficult to see how it can properly be said that there has been a material change in their medical condition. That's just the ordinary meaning of the words. Now, there are some other points in respect of the scheme that need to be highlighted. Firstly, I don't need to take your lordships to it now, but it is important that this is a scheme that has been approved by both Houses of Parliament. That's section 11 of the Act. So it's a positive resolution of both Houses of Parliament that approve the scheme as it is. It's a scheme that's been in place for a long time, since 1964. The reopening provisions themselves have been in place since 1979, and I set out the history behind them in my written submissions. The scheme couldn't be clearer when it was initially, when the reopening provisions were initially included, that they made it quite clear that the board's decision is final, except in these circumstances. Now, the word final has been taken out of the scheme in 2012, but it's quite clear that that is the purpose of the scheme, to ensure that there is finality, except in very limited exceptions. In terms of other parts of the scheme that are of relevance in its interpretation, so paragraph 100, which is at page 68, sets out the procedure by way in which an award is accepted. So the CICA will make a decision, and if an applicant agrees with that, then no payment will be made. There's no requirement to make any payment until they accept the award. And so the procedure is, it's akin to a sort of an offer and acceptance, and that's how it sort of works in practice. But the CICA makes an award and the applicant accepts it. In this case, the applicant did so. For reference, that's in the bundle in the supplemental bundle. We'll come to that when we look at the facts in more detail. So once the award has been accepted, then the reopening provisions will kick in. So the matter then can only be reopened if one of the two circumstances arises. Now, if a matter isn't accepted, if the award isn't accepted, then there is a quite convoluted process, a way of challenge. So the first means of challenge is at 101, which is that the applicant can seek a review of the determination. So that is then described in 117, which is a completely new decision by a new, sorry, at 121 it's explained. So it's a review is conducted by a new claims officer who makes a completely new decision. So what happens is that the applicant disagrees with the award, will usually set out grounds for review and provide new evidence. They can provide new evidence, and then a completely new decision is made. If the claimant if a review decision is made and the claimant doesn't accept it, there is then the appeal process. That's at paragraph 125. The matter then goes to a first-tier tribunal who makes, again, their own decision. So it's a completely new decision of the first-tier tribunal, in which they look at and accept new evidence. They will frequently, sometimes require medical reports to be provided. So there are three stages of opportunity set out within the scheme for an applicant who disagrees with a decision to provide more evidence in order to get the decision relooked at. And it's important because essentially what is happening is the first-tier tribunal, obviously, but also the CICA is making a judicial determination. They're making a determination of what the medical condition is and what the award should be. And so once there is a process by which they can redetermine that with new evidence. But the process, what we say is quite clear from the scheme itself, that the process shouldn't be that once an award is accepted, then that is another route to challenge a decision through new evidence. And if what happens after the first-tier tribunal makes a decision, if they disagree with they allow the appeal, is that they then provide directions to the CICA to remake the decision. So it goes back to the CICA, who then remake the decision. So the first-tier tribunal isn't actually making the decision. Now, if the LXR's challenge were right, that essentially with new evidence as to causation, you could reopen a decision, what you would have within the scheme would be a process whereby an applicant could apply for review, providing new evidence as to causation, apply for a appeal to the first-tier tribunal, providing new evidence as causation, goes back to the first-tier tribunal who make a decision, and then they can introduce new evidence again of causation to say, well, actually, the causation position has changed, the evidence has changed. And we say that simply can't be right. There are very clear means of challenging a decision of the CICA or first-tier tribunal through that appeal process. And what the scheme does, like any judicial decision, is there is clear good reason for why judicial decision should be final. It's only in certain circumstances, very limited circumstances, it can be reopened. Another point of relevance is paragraph 109. Which is reconsideration of a decision by a claims officer before final payment of an award. So there are specific provisions which allow a claims officer to make a decision, to reconsider a decision, where they become aware of evidence or a change of circumstances, which, if known prior to the determination, would have affected whether an award was made or it's an amount. So again, that is very clearly much wider than the medical reopening provisions, if the medical reopening provisions were intended to be as wide as allowing for a change when there is new evidence as to causation or new evidence as to what the condition is or was, then those reopening provisions could have been as wide as that. They're not. And then the other just important point in terms of the scheme, whilst I am here, is looking at the tariff itself and the definition of the various different awards that can be made in terms of the tariff. Now, at page 89, or page 89 sets out the tariff of injuries, and it's important to, when one is considering whether there is a material change of condition, to see what actual conditions payments are made for, what one is looking at when one is applying the scheme. And also it's important to the question of reasonable ascertainability. That is still an argument that the claimant is running, to say, well, actually, in the human rights aspect, to say mental health conditions are by their nature harder to diagnose or attribute cause to. Now, when you look actually at the types of conditions for which awards are made, one can see there are very clearly difficult causation difficulties that arise in many of these types of conditions. So major paralysis is the first one. Hemiplegia, impairment of motor or sensory function of one half of the body. One can very easily see there could be numerous situations in which, where one has a motor or sensory disability, there are going to be very difficult causation, medical evidence difficulties as to what the cause of that might be, whether it is something that the person had anyway, whether it's a long-standing condition they were born with, something like that, or whether it is an assault. There will also be very difficult difficulties addressing whether actually the cause of motor or sensory dysfunction might be a mental health condition rather than a physical condition. And so when the when the claimant is saying, well, you should have a different scheme for mental health conditions, the question is, well, what actually is a mental health condition? Because it's a very blurred distinction between a mental health condition and a non-mental health condition or physical condition, or a mental health condition that has physical consequences. And one can go through sort of the next point in terms of mental injury. One goes to page 90. Is when one is looking at mental injury, one is not looking at the specific type of mental injury. One is really looking at its impact. So, I say distinctions as to exact diagnosis under the DSM-5 are not relevant to an award that is made under the scheme. What the scheme is looking at is the disablement caused by the injury. And I mean, we say specific diagnosis, if there's a misdiagnosis, that's not a changing condition. But this is further reason why the exact specific mental health diagnosis of a condition, which may vary, and in this case does vary between different doctors, doesn't actually mean that there is a material change in medical condition, because actually one is just looking at its impact, i.e. symptoms.
I noticed that the scheme uses the word injury.
Yes.
In that heading, mental injury. Whereas, for example, in the Mental Health Act, the term is mental disorder. And then that's further defined, and there can be different types of disorder. I think the point you're making is that the word injury very clearly focuses attention on the disabling consequences of an underlying mental condition, but is not necessarily focusing on the mental condition itself in the diagnostic manual sense.
And all, I mean, the other, that yes, we say that, but also the reason we are looking at mental injury is because that is what we are dealing with in terms of the Criminal Injuries Compensation Scheme. It is an injury from crime of violence.
Historically, did it start with physical injuries, or has it always included mental injuries? Do you know? I can readily understand that it would have started with, obviously one has in mind an assault. Somebody gets physically injured in an assault, and I can readily understand why you would want to start with that. So I was just curious to understand what had then happened. If you know, if you don't know, don't worry.
Well, I can certainly say this, is that the initial versions of the scheme were simply based on a tortious scheme. So I do not know whether there was a specific reference to mental health injury when we're dealing with the 1964 scheme. It would have said, it did say, again, it's something I can check. I don't think there was a specific reference.
Don't worry.
The tariff itself only came in 1996, which was when the on the Criminal Injuries Compensation Act, when the scheme became statutory. And then just whilst we're there in terms of the scheme itself, again, other injuries, one can simply flick through other injuries and see that there are going to be both difficult causation difficulties and difficulties in terms of distinguishing between whether it's actually a mental health condition or a physical condition. Brain damage is an example. That's at page 91. And so, again, brain injuries are frequently going to cause, or can cause significant causation difficulties, particularly less serious ones, rather than obviously very serious brain injuries might be obvious if there's been an assault, but less serious head injuries will need medical evidence. There may well be causation difficulties. One of the authorities in the bundle that I've referred to is a very tragic case of a brain injury where a person was assaulted. There were a number of different assaults causing a dislocation to the jaw. They had an operation, and as a result of the operation, they sustained a very significant brain injury. And again, that causes all sorts of causation difficulties because one has to try and attribute the brain injury, if one can, to a particular physical assault. But there'll also be, if you've got brain injuries, there will be difficulties attributing that to an assault. Then one has, well, what if the brain injury also caused a mental health injury? Again, that would cause all sorts of causation difficulties.
But causation is dealt with in paragraph 4 of the scheme, isn't it? It's got
Yes.
to be directly attributable, and
Yes.
Williams tells us that feeds into the reopening provisions.
Yes, because that Williams tells us that feeds into the reopening provisions when one is looking at whether there's an injustice in not reopening the award. But what Williams also tells us, if one is going through the process, it doesn't feed into the when one is going through the process, you start with just doing a comparison.
Yeah, because the FTT considered the question of attributability.
Yes, and the difficulty within this case, considering the question of attributability, is if there's no change in medical condition, or it's very difficult to apply the Williams formulation because there's no change which is attributable to the original injury, and so one doesn't really get to the question of attributability because one has already decided that there is no change in the medical condition.
Sorry, big one.
I just wonder if that's right, because if the FTT were wrong in saying there's been no change in the medical condition because of LXR's understanding, they went on to say that the cause of that change was his treatment, not the original abuse.
Yes.
That is attributability, isn't it?
Yes, it does deal with it, but
And the word direct maybe of something.
Yes. So there is, it's dealt with in Williams, and there is a line of cases. It is dealt with, for example, in the case I was referring to, which I'll give you the reference to, because it deals with that question of direct attributability. It is sorry, it's tab 37, which is in bundle 2. And I say that particular instance was an instance of a case, one we see from the facts of 1083 in the Upper Tribunal, of a claimant who was assaulted on, the evidence was that she'd been assaulted on a number of occasions, paragraph 2. There was only one assault that was before the CICA or before the First-tier Tribunal. There may have been, it's not clear why the other assaults were never claimed for. There may have been reasons why there wouldn't be any eligibility because of them, such as the claimant herself was involved. But so there were a number of assaults, and one could see that from the facts at 2 to 3, and then following that, she had a severe anaphylactic reaction to the when she had an operation on her fractured jaw. And one of the questions there in terms of the reopening, and one of the key question was in terms of direct attributability, and that is dealt with in some detail from paragraph 17 onwards. So there are a number of authorities, such as ex parte ins, which is a case involving a break in the chain of causation when a police officer was hit by a car when attending a burglary. BD, so that's at paragraph 18, ex parte ins.
Yeah.
And ex BD at paragraph 19, and then Mr. Justice Dyson at paragraph 21 in ex parte K, another one in terms of where the law is made clear that directly attributable doesn't mean attributable, it is narrower than causation.
That's my point.
Yeah. And so, I mean, that's what the First-tier Tribunal in this case did. They said, look, even if there is a material change in medical condition, then it's not directly attributable to the act itself. But the point is, we say, look, in the first place, it made it a question of fact. There was no change in the medical condition, and therefore you don't really even get to that test.
Could I ask you about page 90 of the authorities bundle? You were taking us to LXR on mental injury, and if I understood your submission correctly, you were saying this focuses on the degree of disablement. The first one, confirmed by diagnosis. What would the diagnosis relate to?
Well, I'll just find it and then. So it's diagnosis of a mental condition, actually. Yeah.
So that's why, as I understand it, you put this on the basis it's disablement flowing from a mental condition which is diagnosed. Because at the end of the day, when we go back to the reopening rules, they're not drafted in terms of injury.
No.
They're drafted in terms of mental condition. Is there a reason for that?
Well, they're drafted in terms of medical condition.
Right. Sorry, I meant to say mental. Forgive me.
Well, the reason is because the injury can be the same. So if you have the same injury, but there is any deterioration of its impact on you, then if you simply said there's material change in the mental injury, it could be said, well, the injury is the same, rather than the condition, the medical condition. That I would suggest could be the reason. It's not clear what the reason is, but it certainly, when one is looking at, well, is there a material change in that medical condition, then one of the factors one would be looking at is, well, actually, what is a material change, when a material change is the scheme deals by reference to impact. And that's the reality of the scheme in my submission. It's about impact of an injury on you, an assault on you, not about the specific diagnosis.
Suppose the impact, whether it's a physical or a mental injury, suppose the impact becomes much worse some years later. And let's suppose that's accepted. Then there's medical evidence to support that. Is it your submission that if the underlying condition has not changed, that can't permit at least a reopening?
No. I think that's the point. That's a point I'm making as to why it doesn't, for example, say the injury.
Yes.
And that's why it says medical condition, because it's quite clear if you have an injury but its impact deteriorates, as in Williams itself, one that will allow reopening, and that's why it's a simple comparison of your medical condition, how it affects you,
That's
rather
Williams,
than
isn't it?
particular diagnosis.
Yeah, it seems to me, at least speaking for myself and subject to any further submission, that medical condition is not a phrase that is being used in a technical sense. For example, by reference to condition as it might be defined in some legislation or a diagnostic manual or something like that. I think it's trying to, we know from the word injustice that the purpose of the provision is to avoid injustice. But you're perfectly entitled to submit that what the tribunal, the FTT did in the present case was it had in front of it a perfectly comprehensible phrase, and then with its expertise, which by the way includes a medical member, applied that phrase to the circumstances of this case and concluded as a matter of fact that it wasn't satisfied. But it might have been persuaded by the evidence that there had been material change in the medical condition. I'm not sure, speaking of myself only, that one should try to give too narrow or technical. The danger is often that through judicial interpretation, the words that are actually used somehow become other words. Glosses are put on things. Well, why do we need to put glosses on this language?
Well, that is, I say, exactly our position. That that is what happened at the First-tier Tribunal. There was, and I will come to this in a little bit of detail very shortly, but in the First-tier Tribunal, there was a very clear case put that there is a change in medical condition because there is a deterioration in someone's symptoms. So it is a pure Williams comparison. You look at how they're affected when they accept the award, and then you look at how they're affected when they're applying to reopen, and you make a comparison. And in the First-tier Tribunal rejected the evidence of particular Dr. Law and said, actually, when you look at in detail at the medical evidence, I say there were 1,000 pages of medical evidence before the tribunal, there is no material change in your condition as between date X when you accepted the award, which was the 18th of August 2019, and when you reapply to reopen the award, or now 2021, 2023, there is no, your symptoms, the impact of the condition on you are the same. and that's the end of it. And the reality of this case was, and is, that is how both parties approached the judicial review in the Upper Tribunal. Both parties accepted and the claimants accepted, look, we can't challenge the finding of fact that there's been no material change in the medical condition, just applying the ordinary words. We say you have to do something different. And if I can just show how all this developed over sort of 20 minutes or so, I think that will assist, and we'll look at the First-tier Tribunal's decision. So we begin with the application for we're going to be primarily dealing with a supplemental bundle for the short period. So in the supplemental bundle, the application for compensation is at S104. So the application is dated the 28th of February 2019.
Can you give me a tab? Sorry, we've got so many numbers at the bottom of the page, I just get lost in them. We're looking...
Is it tab 13? It should be the application, sorry.
13. Yeah.
So there were two applications made on the same day. This one at tab 13, S104, is the application for child sexual abuse, and what we see that from S105. The claim there is, it refers to the incident between 1982 and 1988. There is some discrepancy in some of the medical evidence as to exact time, but it's not relevant for our purposes. The other application that was made for criminal injuries compensation is at tab 12, is at S100. And that deals with the assault by the padre in the RAF. So two applications made. The decision is made at S114 by the CICA in respect of the child sexual abuse application. And the reasons are given at S116, where they state in particular, they refer to the evidence reports from Dr. Boris Yankov, you see that in the third paragraph, dated March 2017, and also Joanne Ruby, who is the, she's a registered psychotherapist. And so the CICA makes a decision on the basis of the medical evidence that is provided for them, and it's a judgment that the First-tier Tribunal would make. And that medical evidence is at begins at tab 11, which is the report of Dr. Yankov. So this is the evidence that LXR has provided with his two applications. And the conclusion of that is at page 96. It's very, very poor copy, but that's how it was. Now, what was very clear to Dr. Yankov and in the medical records was a history of child sexual abuse. And we can see that at paragraph 4.2. So this isn't a case of there being a repressed abuse that is not mentioned anywhere. This is a case of it being before the medical experts, so they know that there are competing causal reasons for his current condition. You can see that paragraph 4.2. There are other potential causes. There was a time when LXR was in the army in Kosovo. And there's reference to post-traumatic stress disorder as a result of that. But the conclusion is at paragraph 4.8. In conclusion, I'm of the opinion that it is likely, on the balance of probabilities, that the post-traumatic stress disorder has been triggered by the alleged encounter with the vicar. there's good evidence he's reported symptoms shortly after the alleged event has been firmly diagnosed with PTSD. So that is the conclusion, that his difficulties were caused by the Padre assault. Now,
There's also the 4.10.
yeah,
Mental health difficulties over the last nearly 20 years are directly related to the alleged encounter with the vicar.
so that's now obviously what the CICA is doing is making its own judgment based on opinion evidence, and that's opinion evidence it based its decision on. And one of the reasons we say, well, you can't simply reopen a decision based on new evidence is because there is a material distinction between the CICA or a first-tier tribunal making a judgment on the evidence, which, if it turns out to be wrong, is something you can't reopen because a judgment has been made, a judicial decision has been made. And so in the normal course of events, if a judge is making a decision on the basis of the evidence before them, you can't simply reopen it because there is evidence that suggests that the decision might not have been correct. The decision has to be made on the evidence that is before the first-tier tribunal or the CICA. So that is the basis on which the decision was made. And then we have Mr. LXR accepting the award at page S. Before we go there, the evidence of Joanne Ruby, one can see that, for example, at 112. Where she apportioned 100% of the psychological damage currently experienced with abuse by the vicar. So actually the evidence at that stage is quite clear for the CICA. So they make their decision and then Mr. LXR accepts it. We'll see that at page 118. It's slightly odd the way perhaps it's termed as full and final settlement. It's obviously not a settlement of a claim, and perhaps the reason for that is to make it clear that this is final, and so that someone who signs it knows that it is final, rather than being sort of a contractual agreement. Now, what then happens chronologically is the claimant is then seen 3 months later by Dr. Jacqueline Pereira Scott, which is at page S121. And one can see the date of the interview is at S123. Now, the purpose of this report, one can see at S123, is because his ongoing civil proceedings against the MOD. And her report is detailed, again goes through the history of the matter, and then at her conclusions begin at page 168. And her conclusions are slightly different, both in terms of the specific condition as labelled diagnosis, but also in terms of causality. So she says, paragraph 324 and 326, he presents with symptoms of low-grade yet chronic symptoms of post-traumatic stress disorder, but predominantly one of 61 and mixed and other personality disorder. And then at causality, the current presentation at 338, which is page 170. Current presentation, predominantly that of personality disorder. He also presents with low-grade chronic post-traumatic stress disorder, likely to remain chronic and enduring. And then in causality, says that the primary trauma contributing to symptoms is the childhood sexual abuse. So the reason in terms of timing that this is particularly important goes to the reasonable ascertainability question, and insofar as that was an issue before the Upper Tribunal, and if it still is. As a matter of fact, what essentially you have is two different doctors coming to two different decisions very closely in time. They're 2 years apart. This is 3 months after the award is accepted. Insofar as it is argued and was argued that Mr. LXR condition wasn't reasonably ascertainable at the date he accepted the award, which is the argument that they were making, well, we say that can't possibly be the case because nothing has changed between August and November of 2019. There's no change anywhere that's referred to. All that's happened is that he has been seen by a different psychiatrist who has come to a different conclusion. And therefore, if it was ascertainable by her in November of 2019, his condition was clearly reasonably ascertainable in August when he accepted it. So, as a matter of fact, the Upper Tribunal, we say that the reasonable ascertainable argument doesn't work anyway. Now, that report wasn't provided to the CICA immediately. What then happened is that the other claim, the claim in respect of the Padre, continued. And so one can see that at...
Just before we go into all this, where is this going to get us, this detailed history? What's the ultimate killer point that you're
I'm just getting to the bit, I'm getting to the bit now as to how it was argued, how it was argued and why, and how the First-tier Tribunal came to their decision. I appreciate that's taking a bit long. So what then happened, I'll give you the brief references at S55, at S55 we get to the, it's S1, S173 and 173 is the decision on the Padre incident, and one could see at S173 in February 2020, the CICA is still referring to the Dr. Yankoff report, but primarily the reason that application was rejected was because there wasn't an assault and therefore not a crime of violence. That then goes to the First-tier Tribunal. The First-tier Tribunal in January of 2021 at 182 make their decision. Again, they refer at 18, the reason for their decision is that there is no crime of violence in the sense, we'll see that in paragraph 7. And again at page S193, you can see that they are referring to the Yankoff report. Now, what then happens is
the page was that?
So it's S55. So it's S193 at I've got paragraph 13. Yes, there. Or Yankoff, paragraph 13. Following that, so that decision is in January, the written reasons are sent in March 2021. The application to reopen comes on the 21st of June 2021. And that's at page S197, which is tab 26. Now, there are two reasons, the reasons put forward as to why the matter should be reopened is, this is where the report of Dr. Pereira Scott is provided at S199. And they say, just above where they start talking about the report of Dr. Pereira Scott, they refer to the First-tier Tribunal decision and say it's clear that in the opinion of the tribunal, he was suffering from serious mental health problems as a direct consequence of the sexual abuse he had suffered as a child, for which he has not received an award of compensation. and they say that that is supported, next paragraph, by the report that they then provide to Dr. Pereira-Scott. Now, the application to reopen is at 200, and what there isn't in this application is any suggestion that there is a change of symptoms. The argument is that there is a change of cause, and one can see that under conclusions, the fourth paragraph down at 200. In light of the opinion, so fourth paragraph under conclusions, in light of the opinion of Dr. Pereira-Scott, the submissions of the CICA and the decision of the tribunal, X is now prepared to accept that his mental health problems have been in large part caused by the sexual abuse and rape he suffered as a child. Now, one can say, well, there's also, that's understanding as well as causation. But there is no suggestion that there is a change in symptoms. And then the symptoms element arises only in the application for a review, because that was rejected. So the application for a review then is at S197, which is tab 27, where again, not tab 27, sorry, wrong one, tab 29, which is S207. That the argument is raised for the first time that there is a change in symptoms, and one can see that at page 208.
That's because of what Dr. Law said.
Yes. So,
isn't that right?
Yes, that's right, because Dr. Law's report is
Looked
attached
at
to
her.
that.
She says that these changes have led to a significant deterioration in his condition.
Yeah. Yeah. So, so that is then the argument that is before the First-tier Tribunal. I've already taken you to the review application was rejected by the CICA, and then the CICA applied to, LXR appealed, and then we get the we get to the First-tier Tribunal hearing, and I've already taken you to the case as put, and this is now back into the core at page 302. I'll now just come to the argument before the FTT and then the FTT decision. So that is the argument that is being raised. We've already referred to it. Paragraph 32, page 302. In the appellant submission, there has been a material change. Three main ways: one, diagnosis; two, his own clinically significant understanding; and three, symptomatic deterioration. And as I say, it's in paragraph 35 when we talk about the reason the understanding is important. They say at paragraph 35 because of its symptomatic consequences. And then they talk about symptomatic deterioration. So what is being argued?
Can I just ask you?
Yeah.
If you just focus on number 3 for the time being,
Yeah.
symptomatic deterioration. On your submission, is that capable of being something that could found a proper reopening?
Yes, if there is a symptomatic deterioration, yeah. So, I mean, the issue in our submission before the First-tier Tribunal was there a symptomatic deterioration? If there was a symptomatic deterioration, the question is that so material that there is then an injustice in the award not being reopened? Because there will be reasons why there might be a minor symptomatic deterioration, which means that it's not unjust when one is dealing with finality to reopen the award. So there might be
But that wasn't the only way in which it was being put, as you've shown us in paragraph 32. Roman 2 was the appellant's own clinically significant understanding.
Yeah.
And your submission is that that's not capable of founding a proper reopening.
Unless it has symptomatic impacts, unless it simply understanding what your condition is.
Well, that was why LXR said it was significant,
Yes.
because it had led to symptomatic consequences. And we see that both in the grounds of appeal on page 289 and in the skeleton argument at page 303, as you've shown us.
You see that in paragraph 35 on page 303.
Yeah,
It explains the clinical significance because of the symptomatic
Yeah,
consequences.
and indeed that's why Dr. Law said she thought it was significant in the subsequent letter.
And so that is then what the First-tier Tribunal deals with. It squarely addresses the case put before it. One can see that from the decision itself is at C251. This is the written reasons, which so the decision begins at 251.
Can I just ask you about that? Do we need to concern ourselves with the decision notice of the 9th of May, tab 19? Or should we, like the Upper Tribunal, simply use the written reasons of July?
The court, certainly from our perspective, simply can use the written reasons of July. There are very minor differences. There are a couple of additional paragraphs, but I don't think they're of any relevance, so, or certainly not relevance to the matter. So it's the one of July that certainly can be used and certainly wasn't used alone. So the tribunal expressly deals with the case that has been put before them at paragraph 14. It's at 253. The case is that there has been a serious material change in his medical condition since he accepted the original award. This is because there has been a change in his understanding of the cause of his mental condition, health difficulties, and this in turn has led to an increase in symptomology and a significant deterioration in his health. So that's exactly the case that's being put. Again, the First-tier Tribunal then set out the argument of the LXR's representative below that there is nothing in the rules to suggest a new diagnosis or an decrease of someone's understanding of their condition and an ability to engage or a significant change in their symptomology does not amount to material change, even that the word is condition is used rather than injury. She did, however, accept that a mistake as to fact does not fall within the reopening provisions under paragraphs 114 and 115. She also accepted that misdiagnosis and misprognosis is not relevant when we're looking at whether there has been a serious change, but is relevant to whether an injustice has occurred. So again, that comes from Williams. It's referred to in my submissions in SS at paragraph 26, sort of explains. You know, in reality, it is best explained, I think, in SS, which I will refer the court to. So it's in the authorities bundle at it's tab 21, so the bundle 1 of the authorities bundle. Paragraph 26. So paragraph 26, page 573 of the 573 of the authority bundle.
Sorry, why are we going to this in a nutshell?
Paragraph 26 just explains, I mean, we commented why a misdiagnosis or a mistake of fact don't give rise to a change in medical condition. And I would ask the court to read that and commend that approach of paragraph 26. Now, returning then to the decision of the first-tier tribunal, if one goes to the Court Bundle, page 253. Behind tab 18. Now, at paragraph 16 of 253, we set out the arguments. The first-tier tribunal set out, we consider the meaning of medical condition. The term is not defined in legislation. We therefore look at the ordinary, everyday meaning of medical condition. And we say that's exactly the right approach. I've referred in my skeleton argument to the authorities that say, well, that should be the approach. Obviously, if Black Clawson is an example, but also one can look at the purpose of again, I'll just refer the tribunal to my submissions at paragraph 52.2. Williams and Central Bank of Nigeria, Lord Neuberger, when interpreting a statute, the court function is to determine the meaning of words used in the statute. The fact that concept and mischief are factors which must be taken into account does not mean that when performing its interpretive role, the court can take a free-wheeling view of the intention of Parliament, looking at admissible material, and treating the word of the statute merely as one item. Context and mischief do not represent a license to judges to ignore the plain meaning of words that Parliament has used. And then Lord Hodgin, R.O., none of these external aids displace the meanings conveyed by words of a statute that after consideration of context are clear and unambiguous and do not produce absurdity. And we say simply, the ordinary meaning of the word medical condition, that is what the tribunal were looking at. And that is what, certainly when we got to the upper tribunal, that is what the parties understood. It was the upper tribunal that went wrong by performing mental gymnastics to try and give medical condition a meaning that is simply not understandable. Now, the upper tribunal criticised the first-tier tribunal for referring to the relying on the dictionary definitions. Now, this wasn't a case in which either party put before the tribunal dictionary definitions. One was simply applying sort of all the ordinary words. But the reason they do that, and one can see that, is by reference to paragraph 19, where they are addressing a specific argument of the claimant that condition has a very wide meaning that can mean anything relating to how a person is. And they do that. They say, if we were purely looking at the word condition, she might be right in stating that there's nothing in the rules that suggests a new diagnosis, etc. Does not amount to material change. However, we are looking at the word term medical condition. It's clear from the ordinary dictionary definition that medical condition relates to a person's illness and treatment. It is clear, therefore, that a change in understanding of the condition and ability to engage with treatment as opposed to treatment is not a medical condition. Now, we say that the tribunal didn't need to do that, didn't need to go there. And it certainly wasn't the submission we made to say the argument can be dealt with in that way. But that is why the First-tier Tribunal referred to dictionary definitions. There's nothing wrong with doing that in trying to ascertain the ordinary meaning. But then,
I understand your point that there's nothing wrong with referring to dictionaries. But if we leave that point to one side for now, the last 4 lines of paragraph 19, medical condition relates to a person's illness and treatment, and it is clear, therefore, that a person's change in understanding. We can read the rest of that sentence. On the face of it, that does appear to be a proposition of law. You may be right, but they seem to be saying this is how we're directing ourselves. Is that wrong?
certainly, I think a lot of that is probably right. If it is the case that a changing medical condition can include a person's understanding as the matter of law, then the tribunal didn't take that, said we can't. We think understanding of itself is not a changing condition. But we say, well, as a matter of law, that's wrong. That's got to be wrong. And
That's a perfectly
right.
comprehensible
Yeah.
submission on your part. That's all I'm suggesting is that insofar as there's a self-direction of law, you say that they were correct.
Yeah, absolutely. And that and as I say, the Upper Tribunal was wrong in saying an understanding of a condition itself can change a medical condition, because it just logically doesn't work. It just doesn't logically flow. Now, and then what they do, in any event, they deal with the facts of the case. They deal with the argument as to whether there's been a change in diagnosis. They refer to the case at paragraph 20, and they, in due course, come to a conclusion, which will come to that there has been no actual change in diagnosis, because there's a medical expert on the panel. And they do not, they deal with Dr. Law's evidence at 22 and 23 and say why they reject it in terms of the merits of the report itself. But they then say at paragraph 24, in any case, we do not accept the evidence before it shows that there's been a material change in medical condition. And they then go through in detail the arguments of Dr. Law. Paragraph 25, although Dr. Law states that LXR experienced dissociative symptoms more frequently and stronger, and more frequent suicidal urges, she has not quantified this. She also says his feelings of grief, loss, and hopelessness and powerless are all new to him. This does not, in our view, accord with the medical evidence before us. So the argument being made before the First-tier Tribunal was previously the symptoms of LXR were demonstrated by anger, primarily against the vicar, because there are all sorts of references to threats to kill. The argument was now that has been replaced by hopelessness and depression. So it's that change of symptoms. That was the argument. But what the First-tier Tribunal said is no, actually, when you look at detail, all the medical reports over all the years, the anger remains. One can see that, for example, at paragraph 42, at page 257. So Dr. Law is saying the anger has been replaced by hopelessness. Actually, the evidence as of 2021, when he applies to reopen, is that there is still that uncontrolled anger. And insofar as the argument was, well, that's been replaced by depression, again, they go through in detail evidence, not all the evidence, obviously, just some of the evidence that shows actually depression is long-lasting. So one could see, for example...
Well, these are all questions of fact for the FTT, and they come to their conclusion at paragraph 39.
Absolutely. So the conclusion at paragraph... paragraph 41, when we look at the details of the medical evidence, it's clear that there is no material change in the medical condition or a change in his diagnosis, although we do not accept that a change in diagnosis by itself amounts to material change. And then 43, at 258, in coming to our conclusions, we also take account that Ms. Sheridan did not dispute the conclusions that Mr. Merritt asked us to draw from medical evidence as set out above. It's clear from comparing this medical evidence that although his mental health has fluctuated over time, it has not materially changed since 2019, when the award was accepted, and 2021, when he applied for medical reopening. There's no material change. And that is the factual finding of the tribunal, and that was not, as I say, to be entirely fair, that is the claimant's representatives took an entirely proper and the correct approach before the upper tribunal and said, we don't challenge the findings of fact. We do not challenge the finding of fact that there hasn't been a material change in the medical condition. Our challenge is to say, well, actually, it's a different thing that the first-tier tribunal should be looking at, which is what was reasonably ascertainable on medical evidence. And so what one sees that in the claim itself, the application for
what evidence would supports that contention, the contention that it wasn't reasonably practicable to discover it? I mean, we know that Dr. Bankoff didn't discover it, but why does that show that it wasn't reasonably practicable for somebody else to have discovered it?
no,
I mean, was there any evidence at all to support that? I mean, the fact that two doctors have two different views doesn't do anything.
no. As I say, that was certainly our position, and the fact that 3 months after the award was accepted, a doctor very clearly did set that out in an opinion, makes it clear it was reasonably ascertainable. And there was also evidence. One of the references is to, in the evidence before the tribunal, was to a report back in 2007, which talked about the claimant. So this is at S. It's a letter, Dr. Galloway to R. Cooper, S47. And the actual opinion is at S49. So this goes back to 2007. Where a doctor said that it appears that his apparent sublimation of his feelings towards his child abuser are reflected in his transferential anger towards the Arme Padre. So that's exactly very much the conclusion that Dr. Pereira Scott reached. Now, just in terms of the way the case was put in before the Upper Tribunal, the argument is at C223, the claim form is at C223. This is a summary statement of grounds. It's then supplemented by a further one, but it says materially the same thing at page 233, which is that the claimant contends. So second is a human rights argument, which we'll come to in due course. But first, CICA and the FTT failed to properly apply the relevant rules, 3.1, giving effect to the object and purpose of the provision. Medical condition must be read as related to reasonably ascertainable medical condition. They then give examples. They say when a fracture of the bone, when 2 years later it becomes apparent that an operation is required, says, although there's been no change in the medical condition per se, paragraph 114 applies because there's been a change in the reasonably ascertainable nature of the medical condition. And then similarly, suppose a victim sustains a mental injury. Based on the symptoms as they exist at the date of application, doctors reasonably assess that the injury was caused by event 1, but 2 years later it becomes evident the injury was caused by event 2. Although there's been no change in the medical condition per se, paragraph 114 applies because there's been a change in the reasonably ascertainable nature. CICA and the FTT erred in failing to apply the rules understood in that way to the facts of the case. So that's the way it's put, and I mean, it's developed in the amended statement of facts and grounds. It's put in the same way that over more paragraphs, at paragraph 3.1 at 230.
Sorry, what was the reference again?
Page 230, it's the same, but just broken up into subparagraphs. And then the detail of then is then at 241, 242.
Which bundle?
The core bundle, sorry.
Thank
Now,
I'm afraid I don't at the moment understand why the fact that at the date of the application, doctors reasonably assess an injury was caused by event 1, and later doctors say that it was caused by event 2, show that it was not reasonably ascertainable at the time of the first assessment.
No.
The fact that doctors reasonably do something doesn't follow that nothing else was reasonably obtainable, ascertainable.
I mean, our response to it, that argument, at the time, and which we still still rely on, is at C 177 to 8 and 183 to 6. So C 177, time behind tab 14, at paragraph 10. That, I mean, it's firstly contrary to clear wording of the scheme.
Yeah.
Contrary to Williams, which simply says you apply the condition as it was, as it simple comparison between when the award was accepted and when it's sought to be reopened, and the comparison that you do is what the condition was as it is now known to be at the time, as compared to what it was when you reopened. And it's contrary to the reality of the facts of the case, which is simply that there was a change in causation, not that there was a change in reasonable ascertainability. And then page 183 to 186, again, we make more submissions, we sort of detail those submissions. Now, so that's the case as put, and going then, and again, just in terms of going back to the way the case was put at C 242, because that develops where this is the statement of facts and grounds, where the claimant sets out why they're challenging, why there is that error of interpretation. And it's a relatively short submission. But again, it's all relates to the simply saying that there should be a change in reasonably ascertainable medical condition, rather than that as a matter of fact there was any other error of law in the First-tier Tribunal's decision. So that was the basis on which permission was granted. Permission for reference is at 216. Again, the same rules apply in the Upper Tribunal as they do in the High Court, in terms of if one seeks to change your grounds of appeal, one needs to apply for permission, one needs the court's permission to change one's grounds of appeal. So that is the basis on which the claim went forward. Now, then when we get to the actual hearing itself, one can see in the transcript, and this was a sort of slightly surprising hearing, but if one looks at the transcript, this is now in the supplemental bundle. And it is...
You'll bear in mind, Mr. Marotte, it's now 12 o'clock and you've got to finish by 2:30, I think you said.
Thank you. So again, just in terms of the transcript begins behind tab 34 at page 278. Now, that puts his case, and one can see at page 287, the judge says to Mr. Butler, I'm sorry to keep so 287 top of this, I'm sorry to keep on about this, but you're not saying to me that the condition changed. No. Right, so, I mean, yes, it's a concession, but it's merely a concession of what is, quite frankly, obvious and quite proper concession to make on the fact the condition hadn't changed, and that was the finding. So that's all consequence of accepting finding 11. Yes, right, okay. That's how I put my case. I'm not mounting a judicial review of the tribunal's findings of fact. I'm mounting a judicial review of the direction as to the meaning of medical condition. Sorry, but if these findings follow from that, findings follow from the direction of your yes, but you're still accepting the findings so far as they go yes. So, you know, that is, say, a proper approach of the appellant. You know, there are authorities, one refers, for example, to Talpada about judicial rigour, about rigour in terms of process and not changing your case. They were clearly not doing that. They were doing what was proper. And at 288, the top of that, top of 288, they say, now I would just clarify or emphasise one point. I don't advance a subjective test that there has been a change in what the victim or the doctor thought was a medical condition. I advance an objective test. Has there been a change in what medical condition could reasonably have been ascertained to be? So again, they're not saying, and correctly not saying, it's an individual's subjective understanding, the victim's understanding of their condition. They're not either saying it's a doctor's understanding of condition, the diagnosis. So that is the case being put, it's what's reasonably ascertainable. And then if one looks at 302.
I'm sorry, I'm lost here. What was the evidential foundation for that which the FTT were required to consider? What was the evidential foundation for saying that the cause of the symptoms could not reasonably have been ascertained in 2019?
I think the basis
all
of it.
All that happens is that a different doctor expresses a different opinion. Why does that show that the first doctor was wrong? And even if the first doctor was wrong, why does it show that it wasn't reasonably ascertainable at the time that the first doctor gave his opinion?
Absolutely. And I think what the applicant was trying to say and what their argument was is that in cases of childhood sexual abuse or other forms of abuse, then victims will frequently repress the symptoms. And so there may be circumstances in which a doctor cannot tell that a particular condition is caused by child sexual abuse because it's never been raised by that person. So I think that is what the argument was, to say, well, in such a situation, it's not reasonably ascertainable. But the point we were making is that that is not this case, because it is plain from all the evidence that that this wasn't repressed. It's referred to in all the medical reports, and you simply have different doctors coming to different views as to what the outcome is. Well, oh, sorry, you look like you were about to ask a question. So, and then, let's put it, page 302. There, again, the end of the submissions, they're talking about what should happen if this decision is quashed, if the appellant's arguments are agreed with.
So which line?
Well, it starts at line 9.
Thank you.
On remission, the First-tier Tribunal will have to decide whether there was a material change in reasonably ascertainable medical condition, and it will have to decide whether the change in what was reasonably ascertainable was directly attributable to child abuse. Now, I mean, how they would determine that second part, I don't know. The first part, we'd say, well, it can't probably be for the CICA or tribunal to determine, because that would depend on medical evidence of the state of expert knowledge at the time. But as then said, now, as I endeavoured to show you, in the decision under challenge, the tribunal didn't determine either of those factual questions. It answered the questions of whether there was a material change in the objective medical condition, which is exactly what it did, and we said it was absolutely right to do so. So that is how the case developed. That is the case that was before the First-tier Tribunal. And we say, firstly, as a matter of procedure, it was quite properly put to the Upper Tribunal that there wasn't a challenge to the findings of fact. There couldn't be a challenge to the requisite standard of diversity and rationality required. The appeal was based purely on a question of law, the question of law being that the First-tier Tribunal erred in not considering what the reasonable, ascertainable condition was. Now, the judge may have had different views. He may have had views that the First-tier Tribunal erred because, as we see in the judgment, they should have considered whether a range of things, including understanding, there was a change of understanding, a change of etiology, a change of diagnosis. All these things, the Upper Tribunal said, could amount to a change in medical condition, and they therefore erred. And they erred in relying on the dictionary definitions. But we say, if that was the judge's view, then I mean there are references in the transcript to to him making that point. So just so one can see, for example, at S. 285, at line 21. Can I just be clear, because some of this seems to be going a little metaphysical. At least in my head, you are emphasising it's a change in understanding of the man's condition, correct? What could be reasonably ascertained about that condition? I think they were saying it's because his understanding has changed. What could be reasonably ascertained has changed. Judge says there are other ways of looking at it, which is to say there's actually changed the condition itself in a way. The understanding is part of the condition. And then at 286, line 11, it seems to be simpler for you to argue, if this is the case, that understanding changes the condition, not just, oh, I now know I've got asthma. It's more than that, is it not? It's not just I thought I had emphysema, but now I know it's asthma. It's different from that. The understanding fundamentally changes in some sort of way that I do not understand the condition itself. So it's clear that, I mean, that is then finds itself in the judge's decision. One can see that reasoning. But in response to that, Mr. Butler says, well, no, one can see that at the top of 287. He says, I'm sorry to keep on about this, but you're not saying to me the condition changed. And that's where he says no. So if a judge thinks that a case has been wrongly put or there is some serious error of law here which needs to be articulated, then it is permissible to invite, to raise that and invite an application to amend. But that didn't happen in this case. The judge raising various considerations, but it really wasn't clear what the judge was thinking. In my submission, it's probably the case that Mr. Butler didn't realise exactly where the judge was going. We certainly didn't know where the judge was going with this. And the respondent can only respond to the case as put. And that's the case we were responding to, and did respond to in all submissions, was the reasonably ascertainable point. So on ground one, I'll deal with this relatively briefly. It's from paragraph 38 of my submissions. I refer to Sainsbury's, supermarkets and MasterCard, which deals with the Supreme Court, so it's Authorities tab 44. Page 1286. I've set out the relevant part.
Court decides on the cases presented by the parties. It doesn't have some roving commission go and sort out the truth for itself.
And Ali and Dink goes into it in some detail. It may be worth referring to that. So Ali and Dink is at tab 48.
Just before we go to the authorities, in your skeleton argument for the Upper Tribunal, you made the point, page 186, paragraph 51, and so forth, that even if the FTT got the meaning of medical condition wrong, they went on to deal with the question of attributability to the original index offence.
Yeah.
And the Upper Tribunal records at paragraph 19 that you had argued in the alternative attribution. That doesn't then resurface in the Upper Tribunal's decision at all, as far as I can see.
No, it doesn't.
Your point was that if they had made an error, it wasn't material, because they decided the case on an alternative basis as well. And that gets lost.
It does get lost, and you know, to some extent, one can understand why it gets lost, because it is an odd thing to try and, when one is dealing with, has there been a change, and the question is, well, has the change been attributable? When in reality there hasn't been a change, and everyone is agreed there's no material change. Then to try and go on to say, well, it's not directly attributed, is somewhat of a slightly sort of hypothetical and surreal.
That may be right, but the FTT's judgment was very clear. They actually spent a couple of pages on the alternative point that it was not directly attributable, even if they were wrong on what they had said up to that point. So, that, as my lord says, that's just left sort of hanging in the air. Even though, if it's a good point, and it may not be a good point, but if what they said in the FTT on that alternative reason for rejecting the application, if that was a good point, then, speaking for myself, I'm left wondering, what on earth is this appeal all about? Because what we're arguing about may be said to be completely academic.
Yes, but you only get to that point if there is, if they got it wrong, so there is a material change in the medical condition.
Yes, I understand that.
So you're going to go to an authority now?
Yes, I was going to go to Ali and Dink, which is at 2022, which is at tab 48.
48.
Yes, that's in bundle 2.
You seem to have an awful lot of authorities. Yeah. The tab. Relevant page is page 1286. Yeah.
And in particular, obviously this is dealt with in some detail. I won't go through all of it at the moment, but
Sorry, could you give the page again?
1380.
1380, I misheard.
So it begins at 1380, and then it deals with the Sainsbury's supermarkets and MasterCard, and then in particular paragraph deals with parts of Satyam, and paragraph 23 when it's dealing with Satyam. Halfway through, Satyam talks about reference to Dillon and Barclays Bank, where Lord Justice Coulson says it was too often forgotten that the pleadings became forgotten as time goes on and the trial becomes something of a free-for-all. As both judges say, the reason why it's important for a party who wants to run a particular case to plead it is so that parties can know the issues that need to be addressed and evidence and submissions, and the court can decide what issues it's being asked to decide. And then there's reference to Al Mabdeni, paragraph 24, where Lord Justice Nugent explained, this goes on to the top of 1382. The present case is not, however, one of the parties seeking to depart from this pleaded case, but one where the parties addressed in their evidence and submissions of cases that had been pleaded, but the judge decided the case on the basis that it had neither been pleaded nor canvassed before him. In our system of civil litigation, that's impermissible misunderstanding of the judge's function, which is to try the issues the parties have raised before him. And then, so at paragraph 25, the Court of Appeal says that there may be some flexibility. One is looking at the question of prejudice in all this. But it reasserts the question is why the judge's function is to try the issues the parties have raised before them, rather than reach a conclusion on the basis of a theory which has never formed part of either party's case. By placing emphasis on prejudice, the point I'm making is that the modern approach to the definition of issues requires judges to adopt a pragmatic approach in line with the overriding objective and not seek to be governed unnecessarily by unnecessary formality, provided it's always just not to do so. So, I mean, there is, a question of flexibility, not unnecessary formality, but that doesn't permit a judge to decide a case on a case that is put by neither party, nor when even the judge refers to it, obliquely refers to what he may be thinking, when the party said, no, that's not my case, to then decide a case on that basis.
Can I just ask you this? Because in principle, you could be arguing one or both of two different things. You could be arguing that the court has no jurisdiction to decide things because ours is an adversarial system. I'm not sure you're going that far, but you may be. The second proposition could be that before a court so proceeds, it has to act fairly. Is it the latter, or only the latter, that you're submitting?
Well, my submission is that the Upper Tribunal erred in this case. So it erred in law. It erred in law because it didn't act fairly, because it decided a case not on the basis before it. So I don't think I need to, and I think in my submission that is right, that was not the case before it. I don't think I need to go as far as saying it also didn't have jurisdiction.
I didn't think you were. And it may also be said, I don't know what Mr. Butler will say in due course, we'll have to wait to hear, but it may be said that what you've shown us so far are private law authorities, and that there may be a more flexible approach which is justified in the public law context, because the courts always, obviously not to raise new issues of fact, but then issues of fact are rarely raised in judicial review cases, but there may be a question about whether a public authority is acted in accordance with law. I can fully understand your point that the court should not engage in a sort of free-range inquiry about things which have not been fairly put to the parties. Sometimes I've seen cases where it may even be necessary to adjourn the hearing. The House of Lords, the Supreme Court have occasionally done that because it occurs to one of the justices of that court that there's actually an important point of law which the parties haven't so far addressed, and the court wants addressed. So I can well understand if the proposition is that the court has to act fairly. I'm afraid I don't necessarily accept that the court has no power to decide a point of law which the parties haven't raised before it, as long as it gives them a fair opportunity to deal with it.
Yeah, and I mean that is right. There is a distinction between a private law case. Well, I'm not sure there is a distinction actually between a private law case and a non-private law case, because even in a private law case, it is open, as one can see from Ali and Dink, for a judge to say, well, actually, or invite one party or the other to say, well, aren't we approaching this in the wrong way?
Well, the test that this court would apply in those circumstances is whether there was a substantial procedural, whether there was a procedural irregularity causing substantial injustice, or whatever the phrase is in Part 52. So it's that element of when this court would say that something has gone wrong below.
Yeah, and that's what we're saying happened here. And we take the point that Mr. Butler makes that and there are lots of references in the authorities. He cites to the court being the guardian of the public interest, and the court can't, if there is something that is clearly legally wrong in a sort of public law matter, it can't simply ignore that. But at the same time, what it can't do is not raise the matter squarely and invite submissions on that particular point. And what happened in this case is there are references to it in the judgment. One can see subsequently in the transcript, one can see subsequently where the judge was going, but not at the time.
So effectively, you're saying that UT decision was unjust because of a serious procedural or other irregularity in the proceedings before the UT. That's the test that we apply under 5221. And you say it was procedurally irregular for the Upper Tribunal to have decided the case on a point that wasn't canvassed, and that is unjust to the CICA because you never had a chance to deal with it.
And you know, there are important reasons for that, and that is possibly why we're here, because what the Upper Tribunal then went on in its interpretation of medical condition was an exercise which we say was impermissible, and wasn't even an argument the claimants were making.
As I understand it, but please correct me if I've misunderstood, as I understand the judge's reasoning, he actually rejected Mr. Butler's point of law. See paragraph 32, for example.
Yeah. So the actual point of law that was raised was rejected and properly rejected, we say. But then I say he came to his own conclusion based primarily on the point about the use of medical dictionaries.
Well, you may be right about that, but the self-direction he gives himself, at paragraph 33, that seems to be at least one of the directions of the law. It isn't the only one, but he says at the end of paragraph 33 that I could see no reason why that should not be a change in his condition.
Yeah.
Namely, a change in LXR's understanding of his symptoms and their causes.
Yeah.
Well, you're perfectly entitled to submit to us that that's wrong in law. But all I'm suggesting is that that's nothing to do with dictionary definition. That's a proposition of law which is freestanding.
Yeah. So moving on to the substance of why the judge said wrong.
Yeah.
So there are two aspects. Ground two is that the judge erred in interfering with a first-tier tribunal decision when there was no error of law. It was an application of the facts to the ordinary meaning of the words changing medical condition. And number three is as a matter of law, the principle that the judge set out in terms of how to approach the question of whether there's material change is wrong. So when one looks at the Upper Tribunal decision, the point about dictionary definitions is paragraph 21 of the so paragraph 21 of the judgment, page 137 of the core bundle. Paragraph 21, the error, and certainly the error in the approach in determining what changing medical condition was the paragraph 21. At paragraph 19, it thereby went wrong. Paragraph 19 of the tribunal's reasons show that it derived a meaning from the definitions, which it adopted as its conclusion and applied to the evidence. It thereby went wrong by treating the definitions as a meaning of medical condition rather than using them as an aid to identifying that meaning. Now, I've already gone to the first-tier tribunal decision, and we say at paragraph 16, they make it clear that what they're doing is applying the ordinary, everyday meaning of the word medical condition, as it's C253. And what they're then doing by references to dictionaries, and of course, there's no reason they can't refer to dictionaries, but is to address a particular argument that is being made about what condition means and whether understanding can be part of a condition, a person's condition. They say that might be the case if you're just referring to a condition generally, but we're looking at medical condition here. But moreover, when one actually looks at the facts of the case, and it dealing with the fact there's nothing to suggest, it's just not applying the ordinary meaning of the words. And having paragraph 21 at 137, called bundle 137, having said that the First-tier Tribunal went wrong by treating the meaning of medical condition by using the definitions in the dictionary as a meaning rather than as an aid to identify that meaning, they then, from paragraph 23 onwards, the Upper Tribunal goes into reasoning that ends at paragraph 30 at 139 by saying, I'm not going to attempt a definition. That would undermine the value of the deliberate threat that the condition carries. Not only that, would be contrary to what I've said about interpreting and applying language in context. So, having said the First-tier Tribunal went wrong by applying the dictionary definitions, the Upper Tribunal itself doesn't even attempt to provide a definition, but says in guidance that is very difficult to understand, and that is part of the problem. CICA has to be able to understand and apply this. Talks, for example, paragraph 28, about words having a core meaning surrounded by a penumbra of meanings, and talks about a car in a garage, which, I say, this is exactly where they're going. 29, condition is different. The definitions that the tribunal relied on and the ones that I've identified are general. Most of them lack any clear core meaning. Medical condition or ailment is an isolated exception. Condition, so there's sort of a reference there to medical condition having a core meaning. Doesn't go on to say what that is. Condition as used in social security legislation illustrates potential range of meaning that it can bear. Depending on circumstances, it can refer to all or any of the following: etiology, diagnosis, symptoms, disablement, and treatment or condition. So now that is the applicant has made an application to amend the claim to include that that particular part of the judgment within the claim form. That is at page C. C98 of the bundle. So paragraph 43 is the amendment the applicant now seeks to make to run the argument that reasonably ascertainable. So run the argument that the change in medical condition can include both the original argument they were running, changing reasonably ascertainable medical condition, but also capable of referring to change in etiology, diagnosis, symptoms, disablement, treatment, and or medication. Now, oddly, they don't say there and understanding, which is the part of the reasoning of the judge. The judge says at paragraph 33 in the Upper Tribunal that the change in condition can include a change in understanding. So I'm not sure why they're not, because that was certainly part of the case, a part of the judge's reasoning. But what we now have is essentially a guidance from the Upper Tribunal that a change in medical condition can essentially refer to anything. Such
The
as
examples that the Upper Tribunal give are actually all different symptoms.
sorry,
The examples that the Upper Tribunal gives, paragraph 29,
Yeah.
I think are all different symptoms. Your mental injury is more prolonged, so you're experiencing symptoms in a period that you didn't expect to experience symptoms in. The control provided by epilepsy medication is reduced, so your epileptic fits are getting more frequent or more intense, and your disc may become more disabling. So you've become more disabled. So that, in fact, all those examples are examples of changes in symptoms.
Well, certainly 2 and 3 are, definitely. One is potentially difficult because then one gets into the question of, well, is it a misdiagnosis in the first place, in the sense that the doctor gave an opinion and the CICA or tribunal came to a judgment based on the evidence at the time that a condition would last X years, but it has now turned out that it's actually lasts longer. So that is not necessarily a change in symptoms if one is simply comparing the condition at the time of the application and at the time of at the time of the acceptance and the time of reapplication. Then if your symptoms haven't changed but they have lasted longer, then there might not be a change in medical symptoms. That is a difficult question, and it's not this case, the question of prognosis, and I think the court should be wary of sort of going, well, we say, look, the Upper Tribunal shouldn't be giving guidance, hypothetical guidance on what might happen in various different cases. It should just be applying this case, the facts of this case, where they're essentially saying you just apply the ordinary meaning. And the ordinary meaning, by reference to the scheme, means is there a change in symptoms, the effect of the condition on you, the disablement.
Well, those could actually be two different propositions. One is simply apply the words used in the scheme. Don't try to give it a gloss. Medical condition means medical condition. You've got a medical member on the FTT, just do your job and find the facts and apply medical condition to those facts, form a judgment. That's one possible analysis. The other analysis I think you're advancing, but I'm not sure, is that you do give medical condition a gloss. You say medical condition means symptoms. Is that right?
Yes, we do, because you are looking at whether there is an injustice, and the whole issue of the Criminal Injuries Compensation Scheme is about the impact of your injury on you. So if you're simply changing the name of the condition, then there isn't a change in medical condition. There certainly isn't a change in such a material change that would give rise to injustice.
So, but why should the law put any gloss on the words that the framer of the scheme, and as you pointed out, as approved by Parliament, has chosen to adopt?
Well, this is a difficulty in the Upper Tribunal decision, because what they sort of starts to do is to try and do that, and then doesn't, because they say, well, I'm not going to try and do that. And trying to give examples of hypothetical situations will only give rise to difficulties. What the Upper Tribunal should be doing was looking at the facts of this particular case, and on the facts of this particular case, where there is no factual, where there is a factual finding that there is no material change in symptoms, no change in the diagnosis, there could not have been a material change in medical condition. Indeed, that was agreed as a matter of objective fact. And just one authority that it's worth particularly, I think, referring to in terms of sort of the ordinary meaning and the approach of the Upper Tribunal. If one could turn, if I could ask the court to turn to it's called Oxford Phoenix. It's at tab 33 of the bundle, so it's bundle 2 of the authority bundle. And it so relevant page is page 1008. This is an Upper Tribunal that goes through some of the principles, but in particular the citation from re F children at paragraph 51, Sir James Munby, explaining the position where he says, like any judgment, the judgment of the deputy judge has to be read as a whole and have regard to its context and structure, not to pass an examination, etc., or prepare a detailed legal factual analysis. There is then a reference to Lord Hoffman in Piglowska and Piglowski, talks about the exigencies of the daily courtroom life as such that reasons for judgment will always be capable of having been better expressed. It's particularly true of an unreserved judgment such as the judge gave in this case. And then in particular, the last paragraph, the last paragraph just before paragraph 52, it's not the function of an appellate court to strive by tortuous mental gymnastics to find error in the decision under review when in truth there has been none. The concern of the court ought to be substance, not semantics. To adopt Lord Hoffman's phrase, the course must be wary of becoming broad in narrow textual analysis. And we say what the Upper Tribunal did is very much got involved in seeking to overturn this decision by tortuous mental gymnastics, when in reality, as a matter of fact, and as the case was presented to it, it had been found that there was no material change in symptoms and conditions, and that was not challenged. Just in terms of the various, so why the tribunal's decision was wrong in principle in terms of what amounts to changing medical condition. I will very briefly go through all the various different reasons raised. So essentially the court talks about, it's capable of referring to etiology, diagnosis, symptoms, disablement, treatment or medication. Now, we say of those references, of those words, i.e. etiology, diagnosis, symptoms, disablement, treatment or medication, the only one of relevance for this particular case is symptoms and disablement. And on the facts as found by the tribunal, there was no material change in symptoms or disablement. Disablement and symptoms are essentially the same thing. Or certainly, if there is no change in material change in symptoms, there can't be a change in the disablement. As to etiology, etiology is just another word for cause. It's very clear in Williams that the approach in Williams is that cause, the material attribute, what the cause of a particular condition is a question that is relevant down the line, i.e. maybe relevant to the question of whether the change is directly attributable to the criminal injury in the first place. But the first part of the analysis is whether there has been a change in the symptoms. And it's worth, if one, I haven't actually referred to Williams yet, but if one goes to Williams, which is at tab 12. The court has, by the way, the transcript of the case rather than the PIQI report. PIQR report, I've got a copy of it if it wants it, but that doesn't have paragraph numbers in, which is really helpful because there's lots of reference in lots of the case law to paragraphs, whereas this has got paragraph numbers in, so it's actually more helpful. So paragraph 25, the Court of Appeal is dealing with the question, paragraph 13 there, paragraph 13 of the 1990 scheme, I think it was, had three separate elements. The first is there should be a change in the applicant's medical condition. Secondly, that change has to amount to a serious change. But thirdly, I would accept the change has to be directly attributable to the original injury. Now, the scheme at the time use the word serious rather than material, but the structure to apply is the same. You can't any reason it's different. But first, there should be a change in the medical condition. And one does that at paragraph 26. As to whether or not there is a change, that in my judgment is a matter of a pure comparison between the condition of the applicant at the date of the original award and his condition at the date when he is seeking reconsideration of his case. The evidence is so overwhelming that the only conclusion the board could reach is there had been a change. The man was living an ordinary life, subject only to mild discomfort. Now his life is pretty well utterly ruined. And that is a simple approach that the Court of Appeal takes. It deals with symptoms, the effect, the disablement. Previously, he was living an ordinary life, mild discomfort, and now very serious impact. So that is the simple comparison that needs to be made. Questions of causation arise only when one gets to the third stage, paragraph 28. It's the same in the case of Lamb, which is at tab, Court of Appeal case at tab 23. And the relevant part is paragraph 32 to 36. The questions are put in slightly different order, but they are essentially going to the same questions. When one is looking at has there been a material change in Mrs. Lamb's psychiatric condition, the Court of Appeal addresses that at paragraph 35. Has there been a material change in Mrs. Lamb's medical condition since the hearing in March 1999? We agree, including this point. There is nothing in the material to suggest that Mrs. Lamb was suffering with florid symptoms associated with PTSD from which she now suffers at the time of the hearing. If she had been suffering these symptoms, it seems very likely it would have been sought medical attention from her general practitioner, which she did not until much later. Our conclusion on this third question is amply supported by the fact that Mrs. Lamb told CICA that her condition had worsened and progressively deteriorated, as an assertion supported by her daughter and friends. So again, the Court of Appeal in that case, in considering the question, is there a material change in medical condition, is looking at symptoms, the effect. Florid symptoms associated with PTSD hadn't been suffered previously, have now been suffered. In terms of diagnosis, I've already referred the court to the part of SS in the Upper Tribunal that in my submission explains this. But going back to Williams at paragraph 35, that's again tab 12. So Mr. Crowe is anxious to attack the judge's approach in this case, which may lead it to being available for suggesting that the emphasis should be on whether or not there was an original misdiagnosis. Mr. Crowe submits that misdiagnosis is not the test. The test is a change attributable to injury. Mr. Crowe is correct. Misdiagnosis or even misprognosis in the original report is not of itself a justification for coming back for reconsideration. Now, what, as I say, the findings of the tribunal, there no change in diagnosis. So it's all potentially completely irrelevant here. But essentially, and just to summarise what is happening here, what my submission is what is happening, is that if the position is that an applicant is coming to the CICA and saying your decision or a previous decision of the First-tier Tribunal was based on a judgment that is now wrong because there is new evidence, whether it's evidence that it was provided at the time, could have been obtained at the time or not. But there is new evidence that the decision you made as to what the condition was at the time the award was accepted when the decision was made is wrong, then you can't reopen because that is a judicial decision. You are simply trying to change a judicial or quasi-judicial decision through new evidence to show that the original decision was wrong. If you're saying, well, there's been a subsequent change of circumstances so that the original decision, the judgment made by the court was not wrong in the first place, but something subsequently has happened, so that the condition now has changed, but not as it was at the time of the original award, then you can reopen if there's been such a material change that there would be an injustice. So it's a policy difference that that recognises the interests of finality, because one can go back to all the law I cited in my authorities about the importance of finality and the cases involving ex functus officio once a decision has been made by number 56 Denton Road was a war damage compensation tribunal. Once a decision has been made, it is ex functus officio, and it would, as Mr. Justice Fazey said, lead to a lamentable state of uncertainty if that could simply be reopened by new evidence to say that decision is wrong. And that's what happens obviously in the court. The county court may make a judgment as to attributability, as to diagnosis, but you can't come back 5 years, 1 year, 2 years down the line and say, well, that was wrong because we've got new evidence. Whether the defendant is the public sector, the MOD, or whether the defendant is a private person. So what the rules are doing are, and Parliament, we say, is doing, is recognising the importance of finality in judgments that are reached on compensation, but having a very small, narrow window of exceptions to allow where something has happened later that doesn't show the original judgment was wrong, but shows that subsequent events have happened that mean it's unjust. It can be reopened in that situation. So that excludes, is the reason why a mistake is excluded. It's why, as was accepted in the First-tier Tribunal and the Upper Tribunal, it's why a misdiagnosis is excluded. It's why a change, in this case, a change in medical evidence as the cause is excluded. And we say it's important for administrative certainty and finality. And you know, in summary, there may be some cases in which there is an injustice. Now, there may be some cases in which applicants have done well out of this because a decision was made, but actually it turns out that that was wrong and they got better much more quickly or something like that. That is, the scheme doesn't say, as it says, can happen before an award is accepted, that it can be opened in a wide range of circumstances. And it's important when we get to the human rights argument that ultimately the scheme is an expression of sympathy. It's a mark of solidarity from taxpayer-funded money. It's not intended to be full compensation. It is part of a system as a whole which supports victims, such as LXR. The system as a whole has supported him for a number of years. The CICA needs to be fair. It needs to be administratively workable. Decisions can't be open-ended. There is a limited pot of money from which, taxpayers' money from which compensation schemes operate. There needs to be certainty. And an application of the rules which enable claims to be reopened would, as we say, lead to an administrative uncertainty and would, certainly as interpreted by the Upper Tribunal, is uncertain because the CICA don't know how to apply it, but there's a real concern that it could give rise to significant claims from claims which were previously closed from many years ago. We don't know the financial consequences of what that might be, but there will be medical developments. if that is sufficient to say, well, actually, the decision made 10 years ago was wrong, then that would give rise to real concerns. The other matter raised, I think, another matter raised in the judgment is obiter dicta in Colfax about a late manifestation of a new injury, which, I mean, I'll only address very briefly. Colfax is at tab 28 of the bundle, at page 790. And this is the relevant part that was alighted on by the judge is at paragraph 22, which is page 790. Now, this is obiter, obviously, because the issue in Colfax was that a applicant had suffered a significant injury and had not made an application for compensation at the time. Subsequently, he had been diagnosed with epilepsy. He already had epilepsy, and the causal link was subsequently identified. He then made an application. So his application was late, and the court was applying the rules of the First-tier Tribunal, and then eventually the Court of Appeal was considering the questions of extension of time, and whether the First-tier Tribunal had erred in not extending time. So it's dealing with different rules. Now, in passing, the Court of Appeal, Lord Justice Briggs, says the power to reopen cases in paragraphs 56 to 57, which is our provisions, subject to its limited availability after 2 years, readily accommodate the late manifestation of a new type of injury. But it's not clear that it would accommodate the late diagnosis of the requisite causal link between the crime and the medical condition which had not first appeared or deteriorated. Then it refers to Williams. The question does not arise directly for the decision in this case, any more than it did in Williams. In my view, paragraph 56 would not accommodate late diagnosis, but in the view of Arden LJ's view, expressed tentatively during the hearing that it might do in some circumstances, I'm content to leave the point open. So that is what the court said in passing. I say very much over because it's dealing with the time limit provision. And what the Upper Tribunal judge says at the very end of his judgment is that, in fact, this is at C. C144, paragraph 52.
C
144. Called bundle 144.
Yeah. Says one interpretation, refers to that citation from Colfax, and then says one interpretation of LXR's medical evidence is that what has happened is a late manifestation of a new type of injury from the sexual abuse he experienced as a child. That would be a matter of the First-tier Tribunal at the rehearing, it's not for me. So, but that issue of whether there is a new injury that is manifested late is not the case that the claimant pursued in the First-tier Tribunal, or indeed Upper Tribunal, or indeed pursues here, because conceptually it's a different case to that which
he was pursuing. If he is pursuing a case of a late manifestation, then logically he would only be saying as from, say, 2021 or 2023. Only after that is my injury caused by the previous the assault back in the 1980s. He wasn't saying that. His case was throughout the time, the injury that he has experienced was caused by the assault. So from 1984, all the consequences since then, and particularly since 2000, have been caused by that original assault. His case was that the evidence shows that is now the case, whereas previously it didn't. And it can't be a late manifestation because there is all that medical evidence of the fact that the sexual abuse was raised throughout various different medical reports and the medical evidence. So we see it in Dr. Yankov's report, we see it in previous medical reports. So it's very difficult to see how it can be a late manifestation of a new injury when the case throughout, or the case in the first-tier tribunal is that it's the same injury that I have been caused throughout. I can just now, the medical experts now attribute a cause to it.
Can I leave you with one question before we break?
Yes.
I think now is about time we will break. Paragraph 114 of the scheme says that a claims officer may reopen an application if the conditions in paragraph 115 are fulfilled. And one of those conditions is that allowing the original determination to stand give rise to an injustice to the applicant. Are there any realistic circumstances in which the claims officer could refuse to reopen, even though it would cause an injustice to an applicant not to? Don't need an answer now, but it's just a curious way this scheme is drafted. It appears to give claims officer some sort of a discretion not to reopen, even if paragraph 115 is satisfied.
I will, my lord, I'll address that after lunch. I think there is an answer to it.
Right, 2 o'clock.
Court rise if able.